I'd like to welcome everyone to our legal panel update. We are obviously on Zoom, and as much as we'd love to be in person, there are still a couple of advantages to Zoom. One's a Zoom mullet. If you don't know what that is, that's the business on top and comfort on bottom, and I'll leave that to your imagination on who's wearing the mullet or not. But the other is that we get panelists from all over the area, maybe they wouldn't be able to join us in person or maybe not as easily in person. We've got a great panel this morning. Most of you know John Giardinelli, our association attorney. He's got 44 years as a litigator, now risk manager, working with 9 associations and over 40,000 members plus. John, thank you so much for being here this morning. We're also joined by David Bright, former litigator, worked with C.A.R Legal and now a mediator, and then Ed Zorn, who is a lawyer and also a broker and chief counsel to CRMLS, which is the largest MLS in the nation. So let me just set the stage here real quick, and then we'll turn it right into our panelists. Ed's going to get started this morning. He's going to cover what's hot in the MLS world, and we know there's a lot going on over there, so it should be some great info from Ed. Then we're going to hear from Dave, who's going to cover liability and trends and some tips regarding mediation. And then John will round out the presentations, covering any types of calls they're getting, some updates on some forms and some fair housing issues. Once all 3 panelists have gone through their presentation, we will jump into Q&A. We'll try to get to as many questions as possible. So feel free to start shooting those over in the chat. If I do not get to you, I apologize, but we will do our best. The only thing that I ask is that we keep these kind of general and informational questions, not looking to get into your personal transaction and legal challenges that you might be having with a client or past client. So just kind of working on that, but feel free to utilize that chat to get some questions in, and we'll get to as many as we can. So with that, I would like to jump right into the presentation. Ed Zorn, thank you again so much for joining us this morning. Is there anything going on in the MLS world out there that we should be knowing about?
Not really. It's just business as usual, right? Not that big of a deal. I'll cover a couple small, tiny little issues that may just completely change how you guys have done business for the last 40 years and flip it on its head. But other than that, it's not a big deal. What I'm obviously referring to are a number of lawsuits and other legal challenges that have been kind of front and center in the MLS world, specifically against NAR. I think at latest count, NAR is now the defendant in something like 13 separate lawsuits. They can kind of be grouped together in a couple of categories, and the vast majority of those do involve the multiple listing service. And so I'm going to kind of walk you through what is kind of happening in that space and what kind of are some of the next steps and some of the things the MLS is actually doing, specifically CRMLS, kind of to prep for where we're going. The first thing I'd like to cover is what I'm going to call the commission lawsuits. And these are large class action cases that have been filed throughout the country. And they're really, the heart of what they're getting to is the sharing of commission inside the MLS. And there's been a lot of criticism of that of late. A lot of white papers and various consumer advocacy groups and even some think tanks such as the Cato Institute, pushing out some documentation about the lack of what they see as competition in the real estate field when it comes to compensation, right? The amount that's charged for commissions. The first case I'd like to talk about is one that started under the name of Sitzer versus the National Association of Realtor. Now it's referred to as Bauman because they did a change in their plaintiffs. And this lawsuit was filed as a class action by sellers of properties in Missouri. And additionally to naming the National Association of Realtors, they also named the largest brokers and franchisors, kind of the big names that you would recognize. So the brokers that got involved represent about 50% of the closed sales in the last 4 years in the state of Missouri. And what their case is about, what they argue, is that the sellers overpaid in commission because they felt like the sellers were forced to offer compensation to the buyer's agent, if you will, either unwittingly or without choice. And the argument kind of goes along these lines. Listing agent comes into my house as a seller, tells me this is what their fee is for them to represent me. and in the same breath and at the same time tells me by putting the property in this multiple listing service, they have to offer some kind of compensation and a sharing of their commission with whoever's going to represent the buyer. And if I don't offer enough of that, then and a high enough amount, then these buyer agents won't show my property, and I may not get as good offers as I want. So there's an encouragement in this system to drive the level of compensation offered in the multiple listing service higher so as to prevent steering. Okay. So that's the nature of what the argument is. Now, where we are procedurally in that case is the case went to class certification. So they're arguing a class, which means they're arguing all of the sellers in the state of Missouri that had one of these brokers representing them in the last 4 years. And they're trying to argue that they're all similarly situated and were similarly damaged. And so that it's a large group. And just so you get a feel, just in the state of Missouri, you're probably talking $600 to $700 million in damages just in the one state. That class has now been certified. So the judge, and it's a very interesting ruling, it's about 50 pages long, and the judge walks through these arguments and has found and ruled that the plaintiffs have met their burden to demonstrate commonality and common issues of law and fact enough to certify this as a class. This judge goes fast. He's known for that in all of his cases. His turnaround from the oral argument to a ruling was 4 days to put out a 54-page ruling. This case is scheduled for February 23rd next year, and this case will go forward at that time. Make no mistakes about it. So, you know, people are kind of saying, hey, these are lawsuits, they're risks, they're 5-7 years down the road. They're not. This case is going to be resolved, at least at the trial level, this time next year. So that's the Sitzer case. And it was very interesting to read the court's opinion and analysis of what was going on, right? He really kind of bought off into this potential claim. So we'll kind of see where that goes. At the same time, there's another case similarly situated, again, focused on commission claims from the seller side of the equation, called Morrell. This is the biggest one. It was the first that was filed. It's in the Northern District of Illinois. That case is just at the briefing process for this same class certification. And NAR has filed a very quality opposition. I think they brought up some excellent points. And by broadening the case, so the Morrell case is in 20 different markets. So it's much broader than just in one state. It goes, I think, in like a couple of dozen states. It does not name an MLS in California. So it is not a California-focused case, but it is 20 different markets across the country. By expanding it in that manner, it makes the case much more complicated. And NAR, I think, has some better arguments in that larger case to try to beat back the concept of a class certification. And they made some good arguments in there. One of those being that, isn't it really potentially the buyer that pays that fee to the buyer's agent, not the seller, right? And there's some arguments that can be made along that line. And they made some of those arguments in that case. So we're now waiting for the judge to rule on that. Now, interestingly enough, there's a flip side of the coin on these commission class actions. And that is, in addition to these from the seller's perspective, there have been cases that have been filed from the buyer's perspective, arguing that it is the buyer that has been damaged because of the MLS rules requiring compensation and sharing of compensation. And the argument on the buyer side is that I, as the buyer, am stuck paying whatever fee in an increase in purchase price based on what this seller negotiated with their listing agent. Why was I, as the buyer who has to pay the actual money, why am I not involved in the negotiation of the commission for the fee that I have to pay? Right? Why is that set by these two other people that have nothing to do with me and don't even know who my buyer's agent is? right? Why do I not have a say in that process? And because of that, I'm charged more than I would have otherwise negotiated for myself. That's the rationale or the argument from the buyer side. That's called a case called Leader. And Leader went up on a motion to dismiss from NAR, and NAR argued a technicality, right? That the buyers didn't have standing to sue in antitrust law because they were not a directly damaged because they were indirectly damaged, meaning they were not the ones entering into these contracts. The contracts were entered into between a seller and a listing agent, and it was that relationship that caused the buyer's damage. So because it's an indirect relationship, the law in the federal level says that person who's indirectly damaged doesn't have standing to sue. So the court kicked their lawsuit out, but did give them leave to amend. So that looked like a great win for NAR, right? By winning a motion to dismiss. So just this week, I believe on Monday, the plaintiffs in the Leader case did file an amended complaint. They tried to overcome that argument, and how they did it is they named 25 different states and expanded their claim to include claims under 25 different state antitrust laws, including California. So they cite the specific antitrust laws in California and are making a claim, inside California on the buyer side. So time will tell whether or not this will, be good enough to overcome the court's objections on the standing issue. Now, a little point of interest here. It is exactly the same judge that has both the Morrell, the seller case, and the Leader buyer case. And when she dismissed the Leader case originally, she cited to the fact that in front of her, in the same courtroom, in front of the same judge, is a claim from the sellers arguing they've been damaged. And she did the common sense thing, right? Hey, you both can't be damaged by the same amount of money, right? One of you is hurt and one of you is not, but it can't be both of you for the same amount. And so she was applying a little bit of common sense, which at times in the legal profession, this may be a shock to all of you, but is sometimes a rarity. And so hopefully she will continue kind of down that road. So that's kind of a brief synopsis of where we are on those are the big ticket items that are driving these commission disputes. One other aspect that kind of folds into this a little bit is the Department of Justice and the FTC. So that they're in the past with, again, specifically related to MLS issues, there was this negotiated settlement where the Department of Justice instigated a 2-year investigation and negotiation with NAR. It resulted in a settlement between the DOJ and NAR with regard to some MLS rules. When there was a change in administration in an unprecedented move, which we mean is it has never happened before in the history of these types of proceedings, the DOJ backed out of a negotiated settlement and walked away. And so there's a lot of bad blood right now between the DOJ and NAR. And there is some concern that the Biden administration, specifically in an executive order, called out the real estate industry and asked the Federal Trade Commission to look into the practices. They use the phrase tying, but if you understand how they define that term, what they mean is tying the buyer's agent's commission amount to this MLS process and sharing of commission inside the MLS. That's exactly what is being investigated right now by the Federal Trade Commission with a request to promulgate some kind of rules. What this means is we could be looking at, in the very near future, a world where the FTC steps in and says no sharing of commissions inside of an MLS, right? That is a very real possibility. If it doesn't happen from the FTC, it's a possibility that these lawsuits result in that, because these lawsuits have also asked the court to issue an injunction. That means an order from the court barring MLSs for enforcing these rules of sharing commission inside the MLS, right? So as an industry, we need to get ready for what does life look like without sharing of commissions in the MLS. From an MLS perspective, we feel that the value of the MLS is quite a bit more significant than just you sharing a commission inside. And the reason we say that is I'm a CCIM. I've closed probably close to 100 commercial transactions. None of those involved a multiple listing service. And guess what, guys? I got paid on every one of them, right? So there's most certainly a history of getting commissions and compensation and fees paid for your services without that being an offer inside of a multiple listing platform. We do it in commercial all day long. It means a little bit of a change in process, but not hard to do. And interestingly enough, the Northwest MLS, which is the MLS up in Seattle, about 35,000 members. So a significant MLS with lots of members in it and good, strong marketplace. They are not an NAR MLS. They're broker owned. And that means they do not have to follow any of the NAR rules. And guys, they don't. They don't follow NAR rules. And they have just announced a rule change where they are changing the offer of compensation in the MLS, that it will no longer be an offer from a listing broker, but instead will be an offer directly from the seller to the buyer's agent. And then inside of what their version of the RPA, right, their purchase agreement, they are adding a section on commissions. And that section says the buyer accepts the offer of compensation, right, as a credit inside of the transaction that the seller made in the MLS, or you can mark a box and the buyer inside the offer itself can negotiate some different arrangement. They can ask for more money. They could ask for less money. They can say, I don't want any contribution. Maybe I'm all cash buyer. Doesn't matter to me, right? I don't need any money. And so the buyer can participate in the setting of that compensation. Now, what that's going to require is that buyer agents need to have written contracts with their buyers, right, before they show property. That is one of the best practices that they're advocating in Northwest MLS. They're actually talking to the legislature right now about making that state law. And for those of you who are not aware of this, California and C.A.R. is got a buyer broker representation kind of group together that is looking at the same issue. So the way compensation is going to get handled is changing. To get in front of it, I'd strongly recommend that you start getting and using buyer representation agreements. And I'll let David and John comment on this. I've always argued that that is already your obligation under Article 9 of the Code of Ethics. So this should not be a shock. I know it's not done, but it is an aspect of the Code of Ethics that's been out there for a long time. And eventually we may find ourselves in a world where we're maybe putting compensation in the agreement, which, by the way, guys, exactly how we do it in commercial. Again, this is not new. It's been done tens of thousands of times. And we may be looking at a world where it's a part of negotiating a fee, just like termite, repairs, escrow, title, right? Why is only the commission fee to the buyer's agent buried in the price and not those others, right? So this is not uncharted ground. But it will require some additional training and just a little bit of shift of mindset. So I think that's about 20 minutes there, Adam. I think that's probably enough to throw down onto the table to start with, and kind of maybe hand it over to some of the other guys to hear what they got to say.
All right, Ed, thanks. And even to those of us that have heard those kind of updates numerous times, it's still super impactful and so important that we understand kind of the history behind it and how those results really are going to impact our business moving forward. So I'm sure we'll get a little bit deeper into some Q&A a little bit down the road. Again, I just want to remind all of our participants that we will have a Q&A session at the end of the presentations. Feel free to use the chat room to start throwing any questions in there. Panelists, if it's a simple question and you want to respond, feel free. Otherwise, we'll try to address those through the Q&A. So Ed, thank you so much for your presentation there. Dave, we're going to move on over to you and get some update. What kind of trends are you seeing out there? What kind of liability issues do we need to be aware about?
Well, great question, Adam. I appreciate that. I practiced law for 45 years. I was a trial attorney. I defended the industry, agents and brokers, and had pretty good results. After 45 years of doing that, I decided to change course a little bit, and I am now a mediator with the group behind me. You can see West Coast Resolution Group in San Diego. We mediate cases all over the state because we do so by Zoom. Anyway, what am I seeing in my new mediation practice? Well, it's interesting because for 45 years I made war. Now I'm tasked with making peace, and it's not easy, but we're getting great results. The market drives liability issues. And in the crazy market that we've all seen, and I know you've heard this a zillion times, the no contingency, all cash offers, where the buyer wakes up a day after close of escrow and decides, I got to sue somebody, I didn't know this or that. And so we're seeing a lot of those cases. We're having fights over deposits, and that gets into liquidated damages. I'm sure John has taught you about how that works. And we're seeing a lot of seller disclosure cases. On the seller disclosure cases, what can you do as agents and brokers to avoid those kind of actions? Because invariably, even though you don't have to mediate under the RPA, I recommend it to agents on both sides. For one, I used to go to mediation as a litigator representing agents to learn about the case, because it's not going to go away. I mean, what we thought initially as litigators was, well, let's let the buyer and seller burn themselves out, because after all, under the RPA, only buyers and sellers are required to mediate to preserve their rights to attorney's fees. And so the agents weren't required. But I loved going to mediation as representing my folks, because I learned a lot about the case. It's not going to go away, most likely. We were always hoping that maybe the buyer and seller would burn each other out and not come after my clients, my agents, but that didn't happen so much. So what can we do about non-disclosure cases? Some of this is going to be real basic, and I apologize, but I got to cover this because it keeps coming up in my mediation cases. If you go to the TDS and the SBQ, what does it ask the seller? Seller, are you aware of the following? And if you check the box yes, guess what? There's got to be an explanation in those blank areas, and there can be an addendum runoff or I can't remember what it's called, addendum for a complete explanation. When I sold my house in Poway, and I'm now up in the Beverly Hills area, when I sold my house, my disclosure was about 15 pages long. The agents thought, oh my God, what are we going to do here? But the house sold, and I haven't heard a thing other than thank you from the buyers. A lot of sellers are under the misapprehension that if they made repairs to various aspects of the home, they don't have to disclose. Not true. I mean, that's why C.A.R, in their infinite wisdom, invented the SPQ, the Seller Property Questionnaire, because that's asking for not only present defects, but past that were repaired. It says that explicitly. And what I'm finding in cases, both when I practice law and when I'm mediating, is that the explanation sections are not real swift. Oftentimes they're neglected or ignored. The box is checked yes under a particular paragraph, and then there's no explanation, or the explanation is vague. It doesn't say much. I saw one the other day in a case I was mediating where in the SBQ, there was a box checked yes, and under the explanation, it didn't talk about repairs or defects. It talked about the remodeling to the house. So, you know, the agent didn't stop and say to the seller, listen, you're not telling these people anything. We got to get into the detail of this. The other area that I'm seeing is a lot of deposit cases, liquidated damages under the RPA. And that format has not really changed. If you are inclined to look for it, it's under the Civil Code 1675 and following. Interestingly enough, and I reviewed this last night, liquidated damages, it's not an automatic. Let's assume that the deposit is 3% and the buyer breaches. The buyer cancels without just cause. The buyer made, in this hypothetical, an offer and attached the C.A.R, removed all contingencies in that offer. And then the buyer decided, well, I didn't get my loan. I don't like the condition of the property. I want to cancel. Well, sorry, but here's the deal, folks. It's not an automatic 3% deposit, not to exceed 3%. The buyer still has the ability in a situation where the buyer defaults or breaches, the buyer can still go to the trier of fact, typically a mediator, or, well, we don't try fact, to a court or an arbitrator. The buyer can still say, look, that amount, that $180,000 deposit is unreasonable. Look at the seller. The seller just sold the property for umpteen dollars more than my contract price. Therefore, no liquidated damages should apply. So please, folks, avoid telling your buyers and sellers that the 3% rule is an automatic. It's not. It's a rebuttable presumption. Those are the fancy words we lawyers like to use. So I'm seeing a lot of those cases. As far as mediation is concerned, it's an interesting process. To state the obvious, mediation is confidential. You can have a party, a buyer or a seller, come into mediation, and we never hold joint sessions anymore. We hold private sessions in virtual rooms or in actual rooms if we go in person, and I do, where what I'm told by one side stays confidential. I can't share information you guys tell me in a mediation with the buyer or the seller unless I have permission to do so. Some mediators are more careful about that than others. Having practiced for 45 years, I'm very careful about maintaining confidentiality. So you can have an agent walk into a mediation in a private room with his or her attorney and say, you know what, I fraudulently withheld that information. I needed the money, I needed to close, so I didn't tell the buyer, my client, I'm the fiduciary, I didn't tell my buyer about XYZ, the seepage pit located underneath the house or the ancient burial site. Well, what that agent just told me in a mediation can't go any further. And if I'm subpoenaed as a mediator, that's not going to happen, first of all. But if I was, I could not testify as to what I was just told. I'm done with that information. So you can feel free in the context of mediation, depending upon the integrity of the mediator and their expertise, to keep your information confidential. But having said that, it's such a great opportunity to exchange information, it being mediation. Now, here's the problem with the C.A.R format. The buyer and seller are required to mediate, again, to preserve their rights to attorney's fees. And they have to mediate before a lawsuit is filed or the initiation of an arbitration. So what does that mean? That means that chances are the attorneys have not exchanged very much information. Whereas once a lawsuit's filed, there's a process called discovery where parties have to respond to written questions and depositions under oath. They got to raise the right hand and swear to tell the truth. And the problem with mediation is that the parties oftentimes are just checking the box. They come to mediation, and I'm talking in the context of real estate. But the same applies. I do a lot of trust mediation, very sophisticated, tough cases. And those generally last about 8 to 12 hours. It's a long day. In any event, when we get to the mediation session, nobody knows anything about the other side's case, which is a mistake. What you can do as agents and brokers, after consulting with counsel, I really didn't like my clients, my agents and brokers talking to attorneys without my first talking to the attorney and finding out what kind of information they needed, and then perhaps acting as the conduit. But I encourage the parties in mediation to exchange information. It's hard to go into the mediation session in a blind. And what we do at West Coast, we, including me, make telephone calls. And I'll spend as much as an hour with each attorney, with each side, discussing the case and finding out what the heck is going on, so that when we start mediation on day one, I've had some mediations go for several days, we hit the ground running. This is not an advertisement. This is how it ought to be done. And a lot of attorneys who retire are tired of the courtroom and tired of the pressure. Well, if they do it right, there's a lot of pressure in mediation, but I settled probably, 50 to 75% of my cases. I was on a panel yesterday with a couple C.A.R mediators who said that one said that they settled 90% of all cases. Well, question how that can be or what the amounts in question are. But these cases with buyers and sellers are difficult to settle because, let's face it, sellers don't have any insurance typically. I mean, there used to be a play to go to the homeowner's insurance and see if they would at least defend the seller, but that's not happening anymore. So for sellers to come up with a lot of dough, one of two things has to happen. They either have to have a lot of money and be willing to part with it, or they got to be able to point the finger at somebody else who is insured. And guess who that is, folks? I was asked to talk a little bit about the new RPA. I like it. I don't know if I'm an exception. I think it is self-contained. It is thorough. When I started practicing law in 74, 75, we had the tear-off receipt. You remember that? The receipt for deposit? And that was about 1.5 pages long with a mimeograph or whatever it's called, paper. And now we're up to 16 pages. But you know what? I went through that. I've taught the RPA. I'm sure, John, you have. I've taught the RPA several times and to attorneys. And that forced me to read every single word in every page. It took a long time. And I think it's really a good document, self-contained. Now, the problem we're having is folks are just checking the boxes and putting in various information in the grid, that first 3.5 pages, but they're not really spending a lot of time with the rest of it because it's easy to fill in the grid. Oh, by the way, one issue I'm seeing now with the rising interest rates, when you're checking the boxes and the grid, are you checking under paragraph 3E1, loan amounts, an interest rate not to exceed, fill in the blank? Because a lot of folks have been caught with their pants down, excuse the expression, who haven't checked that. And so the sellers can argue, hey, you got a loan approval at 18%. What are you griping about? You did not cap that amount. That's really important. There's so many sections to discuss in the RPA, but I used to, when I used to teach to brokers and agents, I'd say, you know what, teach your children well. Sit down with your buyers and sellers before you make an offer, before you put the property on the market, and walk through the document page by page. It's going to take another hour or two, maybe, but what a great process that would be, so that, when you have to testify in a case, deposition, trial, whatever, you can say, my custom and practice is to always, always, always go over these forms. And that includes not only the RPA, but the TDS and the SBQ and all the other forms that are so darn important. The disclosure form. I mean, these folks at CAR, and I was one of them, not in-house, but John and I have been on board legal affairs for, I don't know how many decades, John, probably 4, maybe close to 5 now. God, we're getting old. And we stay on top of this. Yeah, you point a finger at me. Look who's talking. So
In the back of the TV?
I'm sorry.
Always plugged in.
Somebody's talking.
Can I?
Susan, thank you. In any event, what else do I want to talk about? Oh, E&O insurance. What's going to happen there? Well, because this crazy market, I think, is increasing the potential for litigation. In other words, buyers, especially here in California, paying top price, removing contingencies, all cash, doing those silly things. But it happens. And then buyers invariably are disappointed with their purchase, and they look for somebody to blame for that purchase. So I think E&O rates are going to go up. I think it's best to create these practices that we're talking about here, teaching buyers and sellers, attending courses, following carefully. I used to do a fair amount of administrative law work against the Department of Real Estate. When the DRE would file an action against my agents. It's very important to read the changes in the law through the commissioner's bulletin. I don't know, I'm sure you all get it, but how many people sit down and spend time doing that? I just read the winter of 22 DRE bulletin. It's fascinating. There's a fellow there who was giving classes in loan originations so that you could sell loans. And it turns out he wasn't licensed. And I'm not sure if he wasn't licensed, but the courses were not appropriate. They were not, as I understand it, DRE approved. And so there's thousands of people who took these courses because it was a shortcut to learning how to do it. And by and large, they all have been unlicensed, so to speak, for originating loans. Lots of really good information. There's fair housing information in there, the bills that were signed by Newsom to improve fair housing and discrimination issues, implicit bias. There are classes that are discussed, DRE approved. I used to teach a DRE approved course, and it was pretty good. But it was market specific. And so it's no longer being offered. In any event, be careful out there. Use mediation. It's a great process. And there are lots and lots of mediators. C.A.R has a terrific mediation program. There's plenty of business to go around. West Coast Resolution is a private company. Along with, you may have heard of JAMS, Judicial Arbitration and Mediation Services, ADR, Judicate West. There's tons of them out there. We're very competitive in terms of pricing, but your attorney will be able to direct you, send you in the right direction as far as that's concerned. I'm probably close to my time limit, so I want to thank you all for listening. There's just so much to talk about. We could spend all day. I yield the floor to Mr. Giardinelli, my senior advisor.
Thanks, Dave. There's an unfortunate acronym out there called RDR, Realtors Don't Read. And I wish, and I see all these heads nodding, for those that have their cameras on, the amount of times you mentioned the word read the forms, read the bulletins, read what's going on out there. The little bit of time that it takes you to read will save you a hell of a lot of time and headache down the road. So I think that's a very key word that you've got, and hopefully we can get rid of that acronym moving forward. Let me just remind the panelists once again, after John's presentation, we will move into some Q&A. So if you've got questions for any of the panelists, please feel free to put those down in the chat. Without further ado, I will introduce the Vice President of the Raiders Fan Club and our association attorney, John Giardinelli.
Really, I'm the vice president because there's only 2 of us in the fan club. Actually, I live in Nashville, well, just outside of Nashville, and I've become a Titans fan. So I'm a good guy now. What I want to do is touch upon a couple. First of all, thank you both Ed and Dave. There's so many things I frankly could spend my time just talking about some of the things that they talked about, but I wanted to basically cover some of the calls I've been getting. And just, I thought they were kind of interesting because you see the same calls. I know, like, for example, Dave and Ed see the same things over again, and you kind of get a sense that there's a trend or there's something clearly misunderstood by the membership out there. And so a couple of things real quick. First of all, and this is probably one of the most common calls I've been getting over the last couple of months. The transfer disclosure statement is not a contingency. I've been hearing a lot about, well, we waived all contingencies, so we don't need to do a TDS, or even if the TDS comes in late, it doesn't matter. Let me give you an example. I got a call the other day from a compliance officer at one of my clients, a very large company, 600 agents, and they got a TDS in on the buyer's side, and in the agent remarks section, it said, see avid form to be provided, but it wasn't provided. And so the question then became, because of some issues in the actual case, is that a completed transfer disclosure statement? And that was tied in to the arguments that the seller is making that, well, this is a non-contingent offer, which I'm frankly believing we're going to see fewer and fewer of as the market starts correcting itself. The answer is it is not a completed TDS, so that even if there are no contingencies, the buyer still retains the right without a finalized completed TDS, which means delivered, completed to the seller, or excuse me, to the buyer. Until that happens, the buyer retains the right to cancel the transaction up to 3 to 5 days. It is not a waivable contract issue. It is statutorily mandated. So just be careful about that. It is not a TDS. Again, it is not a contingency. Another call that I've been getting a lot of calls about are ADA related issues. I did a program a couple of weeks ago with Steve Lerner, who is the not co-commissioner, he's the deputy commissioner, but he's in charge of legal affairs. I know David knows him pretty well. He's been around for a long time. He's actually a pretty good guy, but he wanted to point out that we were doing a thing on fair housing, and he wanted to point out, look, that right now race gets most of the airplay, right? I mean, you read about it in the newspapers, you hear it on TV, whatever you believe, think about it, it's getting the airplay. But in reality, disability claims are almost triple the amount of claims that come in on race. So violations of ADA issues, discrimination in rental of property, discrimination in sales, issues relating to discrimination in your advertising or in failure to accommodate. But one of the issues I'm getting a lot of calls on, a bunch of them over the last couple of months, are websites. So again, I don't have time to go into it today, but I want to touch upon that issue and remind you that in California, your websites are considered part of your brick and mortar business, and therefore you must accommodate people on your websites in the same type of manner as you accommodate people in your brick and mortar. You have your bathrooms that are set up for ADA, you have all of that kind of stuff. And so the Ninth Circuit has made it clear that these are, this is an extension. And so your website has to be compliant as well. And you need to make sure that your IT people are on top of that. I've got a ton of information. I'm probably going to write an article for your newsletter within the next month or two on the subject. But again, as Adam just pointed out, you guys don't read. Not you guys. I'm sure the 70 or so people that are with us today read everything. But Ed knows and David knows and I know you don't read much, those other people out there. And as a result, we've led great lives because you guys continue to bring us interesting situations. I had a call yesterday and the question came up about possession. What happened was they had a closed +3 agreement, but they didn't put together the SIP. So there was nothing to indicate, well, what happens if possession isn't given? And again, you want to be careful to make it clear. And the new forms that have just come out make it very, very clear that in California, you use an SIP if possession, the seller in possession form, if possession is to be given 29 days or less. If it's 30 days or more, you create a different legal relationship, that of a landlord tenant. And of course, in California, that becomes a very interesting problem for everybody. So if you have a possession issue, you need to remember that the new RPA that David talked about has some provisions in it. If they leave behind debris, if they leave behind stuff, you may need to give a notice of your intent to do cleanup or trash out. And if, again, even though it's technically a breach of contract to not clean up, you want to give that notice. But when you close escrow, remember, when you buy real estate, you're basically buying two things: title, which will transfer upon recordation, and you're buying possession, which doesn't necessarily come with the property if there's a tenant in the property and those kinds of things. So just be aware of that, and you'll want to document it. I don't understand, frankly, anybody that isn't using the SIP, because as I understand it, is currently bundled with your, is that not true, Barbara, that it is bundled with your document? And if you've checked off less than 29 days, you're going to get an SIP. But even if that doesn't happen, you need to fill that thing out. I believe that that could be considered part of your fiduciary responsibility to adequately document your file. I don't know if David or Ed agree, but clearly, if you don't do that, then what happens if in 3 days, as what happened to my client yesterday, the seller doesn't move out or leaves furniture behind so that the moving van can't bring the furniture into the house because there's already furniture taking up space? You've got to get those issues resolved. Fair housing, I think we all agree, is a front burner issue now in lots of different areas. David mentioned the winter article, and there's some really good stuff in there. They've been printing some pretty good stuff at the Department of Real Estate regarding fair housing issues and best practices and all of that. As was mentioned, you're going to start seeing some classes at the end of this year on implied bias. Politically, it's going to be interesting to see whether these are actual classes or indoctrination attempts. But whatever they are, they're going to be mandatory, and you're going to have to take them. And depending upon whether you're a salesperson, getting a new license, trying to upgrade to broker or broker associate, there's going to be different rules for each one of you, and you're going to have to comply. And Lerner told us that there may be a delay in 1 or 2 of the categories because they've gone back to the legislature to get some clarification on a couple of things. So for some of you, you may not have to start taking the implied bias program in January. For others of you, you will. Film at 11 will let you know what's going on. As far as the RPA is concerned, I couldn't agree more with David. I think it's a very good form. Now, there are some problems with it. And so what they're doing right now at C.A.R is they're gathering comments. So if you've got comments, and I don't mean, I don't like it, it sucks, bring back passive removal of contingency. That's not going to happen. It's a waste of your time. But if there's a specific problem with the interpretation of some language, or maybe you're not clear on how to use something, let them know. Neil at CAR.org is the place to go, or you can send an email to me with your concerns. I'll make sure CAR gets it. And what they're going to do is probably by October. Don't hold me to that, the plan is by October at the CAR meetings in Long Beach, they'll probably have a revised RPA with whatever changes they're going to make. And I'm sure the board will have either Barbara or myself or somebody do a class on the changes that will be taking place in December of this year. And so just be aware, they didn't want to do a cleanup right away because frankly, there's so much on your plate right now. There were 60 new forms as it was, so they figured they'll wait till December. Now, Ed pointed out something, and Ed and I have had this conversation many times, and we've agreed that he should be the king of the world and I will be his court jester. And David, of course, will be the consigliere. I'm Italian, I should know how to say that, consigliere. But we all agree, I believe we all agree as lawyers, that the buyer broker form should be mandatory, right? It is here, it's not necessarily mandatory in Tennessee, but in Williamson County where I live, no one will do a deal without the written buyer broker representation. Ed, you're down in Knoxville. I don't know if it's the same or not, but pretty much it's universally used here. And why not, right? Ed pointed out that under Article 9, it says that realtors are responsible to put all agreements in writing, right? Well, isn't the agreement verbally that you have with your buyer an agreement? And therefore, under Article 9 of the Code of Ethics, it should be in writing. It actually says representation agreements should be in writing. I believe that by December, two things will happen to the buyer broker form. Number one, they'll probably consolidate the 3 buyer broker forms that currently exist into one form with box checkoffs, so that if you want to do it without any money, basically just saying, look, if I represent you, then we'll do it this way, or I will only work for a minimum of pick the number. And then of course, I don't know if they're going to include the exclusive representation because there's been some abuse in that arena, but film at 11 on that. The other thing, I'm doing a program in a couple of weeks with, Ed and I are doing a program in a couple of weeks with Sanjay Waggle, who's really, really a smart guy. And he's going to be talking to some of the legislators about creating legislation that will make that form mandatory. Right now, you can't earn a commission unless what? Unless you have a executed listing agreement in writing, signed by the party to be charged, the seller, that clearly defines the negotiated compensation along with all the other things. Makes perfect sense, right? Well, what's wrong with doing that on the buyer side? I don't know if David, if you agree with me, but it's been my experience over the last 44 years that buyers are the most likely plaintiff in a lawsuit. Therefore, it would make sense to me that you would want to have a written agreement with a buyer so that you can create the document that will spell out the relationship. And then in the contract, I just want to parrot something that David said. It is critically important, particularly with the market surging and the interest rates going all over the map, that you fill out that section on the amount of interest that your buyer is willing to pay. Because if you do not, as David pointed out, you create an ambiguity in that contract, right? What's the interest? Well, if you didn't fill it out, it means whatever interest I can get. And so if you go to cancel because you didn't get a loan, or your client isn't willing to pay the amount because the interest brings him out of their area of budget, how are you going to be able to do that in good faith and not have an argument being pushed back that you complied with the agreement? So be careful about that. Couple of new cases just to piggyback on some things. Number one, and this is kind of an interesting case. I've seen it in my practice. I'm sure Ed and Dave have seen it as well, where I will give someone a deed, right? And the deed transfer title to the property, but for whatever reason, we agree not to record it verbally, right? And there's a case, I believe it's called Ring, and that case says that is an unenforceable verbal agreement, right? What happened was the daughter-in-law went ahead and recorded it and borrowed some money, big lawsuit, and the court made a number of findings, that being what I thought was the most interesting of them all. And then there's a case going to David's comments about deposits. Here's the deal, kids, right? You put down a deposit. I don't care how much it is, 3%, 1%. And it's probably the most common argument I see, who gets the deposit if the deal doesn't go forward. Buyers always think that the seller did something so they can cancel. Sellers think, well, you should give me the deposit because I held the property off the market. And two things. Number one, it's a legal issue, right? Somebody like David's going to help resolve it because all the parties have their own opinions of things. And at the end of the day, whether or not the contingencies exist or were removed in good faith are factual questions that should be left to a lawyer and or to a mediator and or if things don't go well at the mediation, to the small claims judge or to the arbitrator. But there's a case. The three of us were told about it at C.A.R. and I'll be darned if I could find the name of the case, but here are the facts, very simple. I open escrow as the buyer. I put down a $72,000 deposit, which is 3% of the purchase price. I then find a house a day or two later that I like better. I've done nothing to perform under the terms of the agreement, but I find a place I like better. My agent tells me, don't worry about it. We've got all these contingencies. We're good to go. So they cancel. The seller, pretty smart guy, has a good lawyer, says, wait a minute. I don't have to give you back this deposit. You didn't act in good faith. You did nothing to get the loan. You did nothing to inspect the property. You did nothing to comply with any of the contingencies that we've agreed to, which means it's a condition preceding to your duty to perform. But it's got to be acted and done in good faith. And so the case went to mediation. It did not settle. It went to arbitration. And the arbitrator said, I agree with the seller. I don't think he acted in good faith. And therefore, they awarded the deposit to the seller, even though they tried to cancel within a couple of days. And because lawyers are always around, and I think as friends, we can all agree that, it always says, an award of a reasonable attorney's fees. And I think by now we can all agree that all attorney's fees are reasonable. And therefore, the judge went ahead and awarded about another $40,000 in attorney's fees. And David and Ed can confirm that's not necessarily a large amount of money for an arbitration. And so the seller ended up getting about $130,000. Now, I'm not saying on its face those facts would be the same for everybody, but what I want to make sure you understand is, look, this is a legal issue. You don't want to be giving legal advice that is relied upon to the seller's detriment or to the buyer's detriment and ends up being incorrect. And the next thing you know, there's a lawsuit, because I suspect, David, that you'll be seeing those people at a mediation over whether or not the agent ought to be coughing up the money for giving bad advice. I don't know if you guys agree, but that's a new case that came down. I dual agency. I was just talking to your property management people about an hour or so ago. They're the number 2 reason you're going to get sued, according to NAR insurance statistics. Number 1 on the hit parade is going to be dual agency. And DRE just wrote a very interesting article in the bulletin that David was pointing to on dual agency, and they pointed out what are the problems with being a dual agent. I'm going to make more money. It's going to be great, right? A lot of buyers are going to want to circumvent anybody and come to the listing agent because they believe they have a better shot at getting the property. Well, the problem is, and this is the DRE speaking, but I don't disagree. Number 1, and this has nothing to do with any of you because you're all good, honest people, but there's agents out there that are going, you know what, this is going to be a really nice payday. I'm going to get both ends of this transaction. I'm not going to necessarily push for full disclosure. We're going to conceal a thing or two because who cares? It's not going to be a big deal anyway, right? So there's that problem. There's more of an impetus to conceal in a dual agency situation where the opposite should be true. There should be more disclosure. There should be more conversation. Another issue has to do with negotiation. What if negotiation gets hot and heavy? How do you handle that if you're representing both sides to the transaction? And then because I'm running out of time, what happens if I'm representing buyer and the seller, and I know Barbara really well? She's the seller. She's been a bud for a long time, and the person on the other end just happens to be someone I've met through this transaction. Is there not going to be a sense of bias towards my friend, someone who I have a long-standing relationship? Because there's problems that are going to come up, and at some juncture, are you not going to have to pick who you're going to represent and who you're going to fall with? I'm not going to talk about the MLS issues because, again, there's so much to talk about. This market is changing, so it's going to be very interesting to see what the new liability. The next time we do this, we're going to see what the new liability issues are, because David's 100% correct. The market will dictate those, and as things become fairer and more even between buyers and sellers, other issues will crop up, and David will see them in about a year, and we'll be moderating those. Of course, the issues that Ed brought up are going to change the very face and nature of how you guys negotiate with each other. I want to emphasize that again, comes up all the time. I also sold my house in Canyon Lake recently, and I had lived in that house for 36 years, right? And we actually put most of our disclosures on discs with attachments because that was the only way we could comply with all of the changes that were made to the house over that 36-year period. So there are no time limits. I saw a PowerPoint that Ed Zorn put together some years back on demystifying disclosures, a great class that he put together. I plagiarized the hell out of it. Well, it's only plagiarism if you steal from one person. I stole from more than just Ed, so it became research. And the bottom line is that there are no time limits on a lot of that stuff. You go back to day one, everything you can remember. I think, Adam, I'm gonna see what kind of questions we have, but I want to end with this. I was at a meeting, a retreat actually, that Otto Katrina, who's the president of C.A.R, was at. And he made a comment that caught my eye. He said that, and I don't know where this statistic came from, and I have no way of knowing if it's true, but it sounds true. And that is that 43% of buyers in the last year or two are showing remorse. Now, even if that figure is half, and it's 20%, that's 1 of every 5 buyers is unhappy with what happened with their non-contingent, non-inspection, whatever kind of offer they made. And I think that David, you're going to be very busy with those issues over the next couple of months, if not a year or so, because I think more and more people are going to do what? They're not happy. Now the market's shifting, and all of a sudden those prices that were skyrocketing, and so, yeah, who really cares? Because I still made out like a bandit. Boom. If I bought in the last term of this big shift, and I bought unsight unseen, and I paid maybe even over appraised value, and I bought a house and it's not what I thought I was going to buy, I don't know if Ed or Dave agree. I think that's going to raise some really interesting issues on a go-forward basis. So I would keep a very close eye on that, and I would just be very, very cautious. And one of the things I hope we talk about during this Q&A is documenting your file, because I've listened to both these guys, and then I've listened to myself and a bunch of others, and I think it's going to be critically important that you guys document the conversations that you have, you document the things that you're recommending. to protect yourselves down the road. Adam, back to you, my friend.
All right. Well, John, thank you so much. And yeah, you've touched on a couple questions that I've already kind of jotted down. And want to remind everybody, this is time for Q&A. So feel free to type your question up in the chat. If it's geared toward any one of the panelists, go ahead and then mention that. Otherwise, we can throw it out there as a whole. I do want to kind of kick things off and go back to Ed. He's been sitting patiently quiet, which I know is difficult for an attorney to do. So let's give him some mic time here. But Ed, you know, there's obviously all the talk about commission and, you know, does a buyer have to start paying for their own commission? One of those challenges is obviously, does it become discrimination against first-time buyers or VA buyers? You know, VA buyers that aren't allowed to pay for any commissions, or first-time buyers that are going to be limited on funds to get into a home. And if it diverts over to a loan, I'm sure the lenders are going to have a premium to finance that buyer's commission. So have those facts or discussions been part of any of the discussions going on at the lawsuit level?
Maybe not particularly at the lawsuit level, because one of the luxuries of being involved in a lawsuit is how real life works be damned. It's kind of like legislation. What really happens in the real world, no one gives a damn about. There isn't a lot of thought of the people prosecuting the lawsuit of what comes next. But I've been involved at the national level with a number of groups of attorneys and practitioners kind of thinking, you know, what's going to happen next. And, you know, you bring up some good points. There is some motion or movement towards, do we talk to the GSEs, right? The Fannie, Freddie, FHA, VA. And do we create, or do they by rule allow for the wrapping up into the loan of the buyer side commission fees, right? The fees that would go to the buyer broker. It's simply because the argument kind of goes like this. Number one, the lender's not damaged or takes no additional risk. Because let's be honest, the buyer fee is already in the purchase price. It's already there. So if you remove the buyer fees from compensation, right, that's a component of the already sold sales price. So if you just took it out and allowed the GSEs to have a rule that said, hey, we will allow a credit in escrow to the buyer for any non-reoccurring closing costs, including a buyer broker fee, right? That means they could use it for title escrow in an amount not to exceed, let's say, 2.5 or 3% of an appraised value, right? That would take care of your dilemma. I think what Northwest MLS is proposing, and what's great about them, is they get to guinea pig it, right? We're going to see whether this works or not in real time. Their rule goes live in October. And again, remember, you can put it into the purchase price. So the buyer's agent under the Northwest MLS model is still getting paid inside of the escrow event, and that price is still getting buried into the purchase price, right? That fee, that buyer fee, is still there. So that, I don't think, would have a problem on a VA side, because again, the seller's still paying the fee just like they are today. So it's just a function of the money comes from the seller, not from the listing broker. And it allows the opportunity for the buyer to participate in the setting of their fee, right? What if I negotiate a great deal with John as my buyer's broker, and I negotiate a fee that's half of what, Adam, you're offering in your listing? Why should I pay the higher list price, right? Maybe I lower the list price and say, hey, I don't want what you're offering. I want to pay John a little less, right? That should be my right as a buyer. So I think there are mechanisms in place and conversations happening to still accommodate the real world, which is we have to accommodate the payment of these buy-side fees inside of some kind of loan product.
Yeah. So maybe a follow-up on that, just because we're talking about the commissions here. So we got a question is, do you think that these anticipated changes will lead to a more litigious relationship relating to compensation with buyers or sellers?
That's a good question, and that's one of the things I've thrown out there in these conversations is one of the big benefits of the MLS system is if there is a dispute about the amount of the fees being shared between the practitioners, right, between the agents, that is handled, through an already well-established arbitration system, right? We all know how that works. You're correct, right? Now what ends up happening if some fee doesn't get paid, right? Does that mean someone sues the seller? And that's what's going to end up happening, right? It's going to go more to the client level at both sides. Or is a buyer's agent, if he gets stiffed by his own buyer, going to have to sue their buyer directly to get paid? Let me be honest with you. That's what we do in commercial. I have had to sue one of my sellers who didn't pay us on a lease deal. Because as you know, leases don't go through an escrow. And by the way, it was a $24 million transaction, right? And we had to sue the client to get paid. So will that happen? Probably. There will probably be more events like that.
Which
And do you
probably
think-
goes back.
Let's say one of the things that concerns me when I look at all this is it going to lead to a lot more dual agency, which may be good for people that do a lot of listing, but is that necessarily going to be beneficial to a client? And again, as we work through this process, that's, I think, one of the things that's going to have to happen is that we don't end up pushing buyers to end up in a single agency relationship, because that frankly isn't, this is supposed to be a lawsuit about benefiting the consumer, and yet there's a lot of things that could end up happening as a quote unintended result that could end up actually harming the same people they're trying to help. I think they call that government, but I'm not sure.
Yeah, that's definitely a topic, John. And I think you've identified what is probably the biggest risk of modifying how fees are shared into this fashion. And let's not kid ourselves. The reason these lawsuits exist is so lawyers make a whole bunch of money. Mm-hmm. And so that's really what the lawsuits are about. It is interesting because when you read the experts' opinions in these cases, guys just realize these plaintiff experts, their mentality is there's no reason you would ever need a buyer's agent, right? They're stuck in the 1980s where they think the only reason somebody would use a buyer's agent is to find a property. They feel like since the property's online, that there's no reason you would ever need an agent. I'm convinced none of these experts have actually ever owned a home or bought anything in the way they write their paper. It's kind of a joke. And they are totally fine with there being no buyer's agent, right? So you can tell there is certainly no rational understanding of the risks and the downside of not having your own representative. And that comes mainly from their erroneous comparisons to what happens in other countries, which, right, by the way, guys, is an absolute train wreck. I've looked at buying investment property in like 5 different countries. I was looking at some vacation rentals in France when we were there on a trip. Now, I'm pretty sophisticated in understanding how to search computers and databases and trying to find what's available. You know what I did? I went down the elevator, the condo we were standing in, and I walked through the streets so I could look at the pictures on the sides of the real estate offices, because that's the only way I could get accurate information as to what was available in the town I was in. Because the data sucked so bad because they had no MLS, no cooperation, no exclusive listings. It's a train wreck everywhere else. And that's what these experts are trying to compare us to. So they're extremely weak arguments, but that is the biggest risk is, are you going to foster, more dual agency? And is that going to be a net negative to the consuming public?
Right.
I'd like to add on to that a little bit, talking about dual agency. When I defended my agents, when the file would come in from the carrier, the insurance carrier, the first thing I would look for is whether or not my client was a dual agent or the brokerage was a dual agent. And if it was, I had to go to the nearest saloon and pound down a couple bourbons, which I understand is quite good where you guys are. And it's a real challenge. I mean, just basically, I understand the financial reasons for it, but how, for example, if I'm a dual agent, how do I get the highest price for my seller and the lowest price for my buyer? You guys have heard all these arguments made over and over again. But when you look at the definition of a fiduciary, it's the highest duty between people, or brokerage and people, buyers or sellers. And how do I have the utmost duty of integrity and loyalty to two sides at the same time? I mean, it doesn't make sense to me from a legal perspective. And those are the cases I'm seeing quite a bit, because there are large offices that have a huge market share. And we see the same folks coming in as dual agents. So I hope you can avoid it if possible.
And some of that is on us as an industry. And that is going to be, let me ask you guys out there, how much time and energy and effort do you, whether you're an agent or a broker training your agents, how much time do you spend prepping them for a listing presentation, right? How many of you have PowerPoints, right? And talking points, and you spend all this time on how to do a listing presentation? How much time have you spent teaching them how to do a buyer presentation and selling your value proposition of why you need a good buyer's agent and what services you provide and how critically important that is and what your fee is associated with that? How much time do you spend doing that? My suspicion is, if you're like most California brokerage firms, you're about 80% on the list side as far as time spent teaching agents how to sell their value proposition, about 20%, if any, on the buyer side, right? That dynamic has to change. That's on us, right? It's up to us to convince buyers that we're worth the fee. And this is an extremely complicated transaction. And you need us to provide these services, and that the fee that we earn for that is worth it. That's our job.
I think it's going to be pretty crystal clear that there should be some significant changes. Whether we have stuff jammed down one of the things that Ed and I have talked about offline is that, we don't want this stuff jammed down our throats. I think we're both excited to see how things work up in Seattle. Thank you for being the guinea pig. But the reality is, for example, something that's always bothered me is if I'm going to hire an agent, it doesn't matter. If you hire a lawyer, you're going to hire a David Bright. You're going to pay for a David Bright, and his hourly rate is going to be significantly higher than maybe a new person in his old law firm. I know you're retired now, Dave, but when you were practicing, there were vast differences between hiring a lawyer that's, let's call it seasoned, rather than something else, right? So Ed and David and I, we're seasoned, right? And we're worth more, frankly, per hour than, say, a brand new lawyer. And that's the way our industry operates and pays charges. You guys don't do that. If I could hire a Terry Ryan, and I could pay exactly the same for a Melvin Schmidlap who just got his license 2 weeks ago. And I don't think, and yet there's no, really generally speaking, there may be a difference in the split at the broker agent level, but there's no difference in the amount that the client's paying, and yet the client is clearly not getting the same level of service that that he could get from hiring a more experienced agent. Now, if you fast forward that to a time where the buyer's paying for their own agent, I think that's another consumer issue that becomes problematic, because if I'm a first-time home buyer or somebody that's got really tight finances, I'm only going to be able to afford so much, as opposed to somebody that's well-heeled that can hire a top-notch agent, because again, and the differentiation between how things might look down the road. So there's just a lot.
I think, John, the answer to that problem is a bit of what Northwest is proposing, right? So if I'm representing a first-time homeowner who's got to scratch and save every penny for the down payment, it has absolutely nothing to pay me as their buyer agent. then why can't I just in the offer itself have a line that says seller agrees to pay X dollars for buyer's fee? And if the list price is 500,000, why can't my offer be 500,000 plus whatever that fee is?
Right.
That's exactly what we do now. Right. So I think the oh my gosh, a first time buyer or VA will never get representation is a red herring. There is a way to still get that person's fee paid. You just have to adjust the price you pay. And if on the flip side, if I'm buying that $500,000 house and I'm an all cash buyer and I can cut a check for my own buyer's agent, then I'll pay your full list price of $500,000. The dollars that go to the seller under both those scenarios is absolutely identical, just like it is under our current system. This is not that monumental of a change. It's just a change that gives a little bit more control to the parties and requires us as agents to sell our services and value proposition to buyers. Those are really the only changes.
But it's going to require, I believe, adults to be at the table to eliminate the emotion. Oh my God, we're changing, we're going to ruin this. And it's going to require real thinkers to sit at the table. And that's why, you know, people that are on boards that are sophisticated boards, you know, that are well-educated boards that actually sell real estate are going to be critical, and the vote to get those people and the people that are going to do the thinking to get to the next step are going to be critically important. Because if you end up with a bunch of emotion, if you end up with a bunch of yelling, and that's what worries me about having with all due respect, and I'm not trying to be political, but having the government start shoving stuff down everybody's throat is probably the worst thing that can happen, because they don't know the industry and they really aren't, frankly, they aren't necessarily looking for a solution that is going to take into consideration all those issues.
And that's the significant risk that we have as an industry. If we don't do anything and we just sit back, then you're going to get some 24-year-old kid who came out of an Ivy League school living in his mommy's basement, writing the rules about how we're going to do our business. That's what's coming down the pike.
Right. I know that, David, you and I attended a meeting one time where that 24-year-old, I don't know if she lived in her mom's basement or not, but she had gone to 3 Ivy League schools, and she was the one writing the 1,200 pages of regulations dealing with the 6-page law on do not call. And she couldn't answer any of our questions. She couldn't answer any of our questions because she was just simply writing rules. They sounded great. They were brilliantly written. She's a brilliant person, but she had no concept of what the industry she was writing them for was about. So I just think it's going to be a really, really interesting couple of years. And
is this really that different, though, guys, than the move from sub-agency to buyer agency? Right? We've already done this shift. It's not like this has never happened before.
So Ed, let me ask you this, because there's been a few comments and questions about writing in that, you know, that buyer's agent's fee. Is it as simple as the example you gave, where I'm gonna write in, you know, as part of a seller closing cost, I'm just gonna add it as a buyer fee, and if the price needs to be adjusted, that's what it's doing? Or is there like a special addendum or form that maybe Northwest is using to specifically address the buyer's commission?
Oh, it's certainly the latter, right? Well, I'm not saying stop what you're doing now and just start writing in changes, right? This is an organized process. And absolutely, Northwest MLS has modified their forms. So in Northwest MLS, they also control the forms. So they're the MLS and they provide the forms library. So this would be the equivalent of C.A.R stepping up and saying, hey, we want to modify the RPA to include a sentence about how the fees are going to be done, and then have an addendum on some level of adjustment. So this would be what's being proposed is within the forms themselves. This is not just people drafting things on their own, right? This is the new way that everybody is going to do it.
And that's being looked at the C.A.R level. there's a buyer broker task force. And they're looking, everything that we've been talking about, one of my clients is on that committee, and they're looking at all this stuff. These are successful brokers working with the C.A.R legal staff, and they're exploring potential new laws. They're exploring changes to forms, talking about a buyer advisory form, talking about all of the stuff that we're talking about, and then some. And again, we don't want to end up with a ready, fire, aim kind of approach. This stuff has to be thought through, because once you make one decision, you don't want to find the wombat popped up in someplace else and you end up playing that game. So it's a complicated issue, but people like Ed are at the table, and there's some pretty sharp people working on this stuff. Just got to be, you guys, you understand, number one, it's not going to happen tomorrow, but number two, there are going to be some changes, and you guys need to be aware of them. And then I'm going to quote something that the attorney for NAR said to us. Very smart lady, Katie Johnson. I know we've all got our opinions of things, but Katie made a comment. She said, it's time that real estate professionals sold the industry, because a lot of people think what Ed said before, that, you guys can be fashioned after the European model, but you're not. You do a lot of different stuff. David talked about all the liability issues, and there's so much more that you guys do. How do I say this nicely? Ed, help me out. David, help me out. You gotta say it. You gotta not shut up about all the things you do because you're in a hurry. David, you said something at a panel we were on. You gotta slow things down a little bit and think through some of this stuff, and then tell people, look, these are, have something, give them something that says, these are all the things I'm going to try and do for you. That's why the buyer broker agreement, I think, is so critically important, because it does have a lot of that stuff in it. So anyway, I just think you guys need to do a better job, frankly, of selling the quality of your industry, not necessarily allowing these lawyers to talk about the negative aspects, because that's what's happening. They've got the floor, right? They've got the floor right now, and you need to get it back. And then you need to sell your position of why some of the things that you do make common sense. Anyway, my opinion.
Definitely agree with that, John. Let's switch gears a little bit to a potential liability issue. Houses are not flying off the shelves like they were. Their agents are having a market and do open houses again. And I heard at our marketing meeting just this week, someone promoting, hey, I've got 3 listings available. Who wants to sit in on my open house? Let me know. John, recently at the Brown Bag, you said there could be some concern with an agent from a different broker sitting in on your open house, or you as an agent not working for that broker attending their open house. Could you maybe touch on that a little bit? And David, feel free to jump in if you're seeing any liability issues just sitting on an open house, which a lot of people have used as a lead generator in the past.
Well, don't do it. I guess I'll leave it at that. I mean, the fact of the matter is if I'm an agent for broker number 1 and you're an agent for broker number 2, and you've asked me to sit your open house, are the 2 brokers on board? Is the seller on board? What are the duties and the liabilities? There's a company out there, I'm not going to mention its name because it's being looked at by DRE, but there's a company out there that actually is a website you can go to, and you can put your name on, say, hey, I'm an agent, I'm available to go sit your open house, do your showing, whatever. Okay, what are all the issues? I asked Steve Lerner about it, who's the head of legal at DRE, and he said it's not against the law per se, but you better know that if there's a problem, we're going to look to see if you checked all the boxes and if you crossed all of the things you needed to cross. One of those things, and David, your thoughts, better have an additional broker form so that it's clear, hey, there's an additional broker that's going to do some of the work, right? There's an additional agent that's going to do some of the work and is being supervised by that broker. That's the kernel, is that brokers supervise their agents. Well, if I'm working for Wendy, but Barbara's my broker, then who's in charge? Is it going to be Wendy, who I'm showing for her office, or is it Barbara, who my license is hung with? And that creates a lot of issues, I think. And so, you know, I'm lazy, I'm a risk manager, don't do it. Figure it out. But if you're going to do it, cross all the T's and dot all the I's, because you could have some problems. And that came straight from the DRA.
Thanks,
Well, I agree
John.
with that.
Go ahead, Dave.
Yes, Dave, if you have anything to add to that, so.
No,
Perfect.
I think the lines have to be drawn, and there is a lot of confusion in the public sector as to what exactly the agents do, what their purpose is. I mean, again, I'm going to go back to being an old guy, started in the business in 74, 75, and where we are now. I mean, the forms are incredible. And I think by being a really good fiduciary and protecting people, money will follow. That's always a given. If you're in it for a quick buck, then you know you're going to be exposed to liability. But I agree 100% with what John is saying. Don't do it.
So John, you touched on it a little bit earlier, and I'm sure we could do an entire class on how to document a file. But if you were to pick, and David, Ed, question goes for you as well, you know, maybe a couple of key points that you would recommend are absolute musts in documenting files and things to help prevent you getting in trouble down the road. What would those top things be?
Don't say something stupid and put it in your file. I've had those cases. I know, David, you probably haven't. Ed, you've probably seen those transactions where somebody passion took over. I mean, I know in the hate speech area, every case I've seen so far in the hate speech area started out as a conversation between two agents. And then it escalated into crazy, okay? And then somebody said something. So number one is write like a professional. You've all heard me say this before, make believe you're writing to your mother or to a jury, and don't put anything in there you'd be ashamed for them to see down the road. Number two, learn how to document conversations that have taken place either through email and or text. If Ed and I agree on something relative to our transaction, then someone needs to write a confirming short email. I prefer emails to text because they're easier to save. And basically now it's the ball's in Ed's court, because I'm saying to Ed, this is my recollection of our conversation. If he doesn't respond, now I've got something in writing. So number one, document what you've agreed to. Number two, number three, I should say, be careful what you write intelligently. Don't put in things because you're angry. And then lastly, save everything that is important, and document things you've done for your client that you've done well, right? Make sure that those things are in your file, and know what you can and what you can't get away. There's so many. It could be, like you said, Adam, any one of the three of us could do probably an hour and a half on proper documentation of your file. I know that in my risk management class, and I've stolen from Ed's risk management class, and I've stolen from Dave's risk management class, is there are key things to do. One other thing, and then I'm going to turn over to either Dave or Ed, is be careful what you say in terms of quantification. Dave, you and I had that conversation. Don't put things like, I saw 6 cracks, or it was a water stain. Just be careful about that, because there could be more than 6 cracks, but now you're stuck, right? It could be something besides a water stain. And then be careful about interpreting things you're not qualified to interpret, right? You disclose facts, but there are cases that say you don't necessarily need to interpret them. And so be careful about that. I know, David, you got a lot more to say about that. So,
well, as time permits, one thing I always encourage my agents to do is to document important conversations. For example, this email will confirm our conversation of today's date, in which we went page by page through the home inspection report. As we discussed, I am not going to order the specialty inspections that are being asked for or suggested or recommended by the home inspector. That's up to you. If you don't do it, you're dumber than a rock. No, I wouldn't quite say that, because it leads to my second point, which is everything that you write, anything printed is going to be blown up to the size of a billboard if, heaven forbid, you get to court. And so you really, I mean, it's a matter of discipline and learning how to say what's important, not too much, not too little, but to confirm important stuff, just like going over the home inspection report, or this is to confirm our discussion in which we went over the transfer disclosure statement and discussed the following. I mean, I don't think you can document enough in a file, because everything will be brought into question once you get into court. I've sat there in court and watched stuff get blown up in front of the jury, and your heart drops, although you know it's going to happen anyway. But it's just, you can't be too careful. That's all I'm trying to say.
I think my comment would be, think about the technology you use, right? And there are some technological tools out there that help with some of these things. I know there's a number of products out there that help you with your transfer disclosure statements, right? Where you can send the transfer disclosure statement to a client. It's kind of like a TurboTax experience where they can then ask questions and you can answer those questions, and all of that gets tracked. Think about the technology on how are you guys getting your texts into your file, right? That's the number one thing as lawyers. This is what will end up happening. Remember, it's 3 years from now is when this is all coming out. And now you have this dispute, and for a fact you had this text where you addressed this issue real directly and really is great, and you have no idea how to get that back, and it's not in your file, right? That's a problem, right? So think about the technology you use and how do you correlate all of those various mechanisms of communication and get them into a single file. And for God's sake, please read everything before you hit the send button. So when you're mad because the other agent is a moron, which we all know happens, go ahead and write that flaming email and then stop, go get a beverage. I'm not saying what kind or how strong. Come back and reread that email or text before you send. Okay.
The emotional emails, huh?
I've actually
write them, just don't send them.
I've actually had to settle a couple of cases. First of all, I settled a case just like Dave talked about, where my client didn't write that. They had gone through and they went through all this stuff. It had been recommended in the inspection report that there be a roof guy come out and do a roof certification. They said no, it wasn't documented anywhere. And now all of a sudden your case goes from, I told you you should have done that, I'm no longer liable if there's a problem, to what? Prove it, right? Remember, you're the fiduciary, right? If I have a conversation with a client as a lawyer, right, who's the jury going to believe or find is at fault if they don't remember the conversation the same way that I do? So you want to document that stuff, and then again, and not only be careful before you send it that you read it, but be careful when you hit reply all, because you may not want everyone on that thread to see. Ed knows that I have a case from hell right now, and this clown, and he is a clown, not one of the bad ones, not one of the good ones, and he's added, I think he's up to 49 people on the thread. And we're just sitting here going, oh, write more, because every time he sends out an email, 49 people see what he's writing. And so you want to be careful not only what you say, but who you say it to. He has basically used some incredible, I didn't even know people could talk like this anymore, some incredible homophobic comments about some of the people involved in the case. Well, 3 of the arbitrators are gay. and he's put them in the thread. It's just insane what people do. So be careful. Emotion will get the best of you, and just be careful who you send stuff to, and then be careful what you say. Just do that. Back to you, Adam.
Yeah, for those that can't see the chat, I'm not familiar with this, but someone wrote that touch copy, TOUCH copy, will take your entire text chain and turn it into a PDF as a conversation, including any photos. So something, maybe look into for those that maybe can't see what's going on in the chat. Ed, I want to go back to the lawsuit, the class action lawsuit in particular. I believe you said in Missouri it could be up to $600 million in damages, just one state. Is there threat of copycat lawsuits? And I mean, if that starts exponentially rolling out, I mean, is NAR going to have an existence still? How do we cover something like that?
I mean, to be blunt, no. I mean, that's the tiny case, right? Realize the Morrell case is estimated somewhere between 4 and 6 billion with a B, right? So no, none of these organizations will survive. And yeah, we are concerned about a potential copycat case, right? If someone uses the concern about the fact that a class has now actually been certified is it can act as a blueprint for another attorney in just a state-only case to come after it. And in California, again, you would be talking, probably a claim in excess of $1 billion. So no, none of the organizations as you know them would survive any of these.
Who would pay that, Ed? Is there insurance that covers any of this stuff?
No. So realize when you get antitrust insurance, right? Antitrust insurance only covers lawyer fees. There is no such thing as an antitrust policy that covers the payment of damages, right? Only fees. And realize damages are trebled, meaning they get tripled, right? So no, there is no survival of these entities. And David, that's one of my arguments is, what is NAR doing as far as potential settlement of these cases? While, the plaintiffs, they may get a nice piece of paper that has a couple $2 billion on it, but there's no entity around that has that much money, right? Let's be honest, the money they're chasing, guys, is in the pockets of your agents, right? It's not in the pockets of a franchisor. It's certainly not in the pockets of NAR or an MLS, right? That money got spread out amongst actual real estate agents. So until they sue that group, there is nobody to pay. The question becomes at a state action, and this is what they did in Missouri. They didn't, they sued actual brokers, right? That's where the actual money is.
Jeez.
So no, the industry, as you know, it does not survive.
Any idea what the industry looks like after that then, if that goes? What's your crystal ball?
This is why you form corporations and you have good risk management. And as hopefully you guys have your company set up the way they should be set up, as do associations and MLSs, right? The life will go on, right? It would just be potentially with other people in charge and other relationships being forged. It's not going to be the end of people transacting business, right? But things will change. Again, the question is, as an industry, as a group of professionals that are organized, what are we going to do? We're just going to sit back and wait? Or are we going to be the drivers of change and do what is good for consumers? A great example is what's in front of us right now, right? C.A.R is doing this, buyer representation agreement, right? Is that going to come out and highlight and default to being an exclusive? Really? We got mass antitrust litigation. And as an industry, we're going to pump out an agreement that is an exclusive? Really? You guys sell me on how that works for the consumer. I understand why it's fantastic for us as brokers. Got it. I'm a broker, okay? You guys walk me through how that's fantastic for a buyer. And is this the time that we do that? we're really going to do that? So I would argue, Adam, it's in our own hands, right? We're sometimes our own worst enemy. We need to start doing stuff that's great for consumers.
Yeah.
Dave, were you raising your hand, or John, did you have a comment?
Just again, keeping an eye on that buyer group. I think just the opposite may end up happening, which is that they probably, if they do an exclusive, it's going to have an automatic time limit. What's happening with the exclusive buyer broker is people are putting in a really long exclusive period, and they're sitting back doing nothing, saying, if you buy a piece of property, remember me because I'm getting a commission. It's a clear breach of fiduciary duty, but I think what's going to end up happening is just the opposite. If they do leave, and I'm hoping how do I say this without sounding, I'm hoping that they show some real courage and really make the changes that need to be made.
Yep.
My experience, and again, I'm an outsider looking in, I'm a guest here. You guys were my first association, but I got to say, sometimes, and I think Ed hit it on the head, the industry is its own worst enemy. They need to show they need to recognize times have changed over the last 40 years, and we need to take a look at the way things are done now, really, and need to make those changes. I don't think we're going to see only an exclusive buyer broker. I think it's going to really default to, and the way it should is that, you can say, hey, I'm willing to work for no less than 2%. And if I don't get 2% from the seller, then buyer, you'll pick up the tab. That probably doesn't bother me too much, but it's going to have to be something that is going to be going to leave it to the parties to negotiate, because I think that's really going to be one of the keys in terms of antitrust. I saw a question before. I just want to comment on it. I don't know, Ed, you're in. By the way, you guys should notice that your MLS attorney and your association lawyer have both left California. So you might want to notice that. But the fact is that somebody mentioned, well, we're going to get like New York, and you're going to need an agent and an attorney at every closing. Yeah, we do that here, right? There's usually a lawyer. Usually it's the title company lawyer is at the table. He heads it up, or she heads it up, and then everybody's at the table. But the nice thing about that is, number one, from a human being standpoint, is I now get to meet the sellers and or the buyers as a human being. It's not one of these paper things. And number two, if somebody has a question and or there's an issue still remaining, it can get taken care of right there while everybody's at the conference table. And I've done it now quite a few times. I don't know if Ed agrees. I think it works great.
I love it, actually. I've closed almost 30 transactions out here over the last few years. I love it. David, I think you might be able to comment on this. People who like each other and have met each other usually don't sue each other. It's easier to sue some seller person out there who screwed me that I've never met. A lot harder when you exchange keys, you shake hands, you exchange text numbers. If you have a question about the property, give me a call. That's what happens to us at a closing table. Right. My sister, when she bought her house out here, they're still good friends and have the old sellers come over for a family get together. Right? Those people will never sue each other.
Yes.
Right? So there is this camaraderie that happens at a closing table.
Don't look down on that East Coast closing style.
Yeah.
It actually, I will tell you from my personal experience, having talked to the president of our local association and a number of others, and to Ed, that the litigation here is not nearly as, well, certainly not as instantaneous. And I've seen 2 litigation threats that, and both of the potential plaintiffs were from California. One was a lawyer who bought a $7 million property, and the other was also a Californian. And Californians tend to say more. And so, but again, you get everybody in a room, right? And it just creates a different vibe, I guess is the term. It just changes things dramatically.
Yeah, you resolve things with a phone call because you've met them.
Yeah. I mean, we had an issue that came up in one of our closings. It was a personal closing where I had noticed that there was an issue with a blanket mechanics lien on a property, and I didn't see anything showing that it had been released. I asked the question, the lawyer goes, "Oh my God, I missed that," perfectly honest, and took care of it, and boom, we're done. Problem solved. So it allows people to.
But on the other side of that, and I understand what you're saying about, having that closing table and seeing everybody face to face, but we know that California has a massive affordability problem right now. And so what does adding an attorney into the transaction, are you saying that's going to take place? Not saying it will, but they're in Tennessee. Does that take place of another closing cost?
It
So that
does.
it's
We don't
not-
have escrows. They don't do escrows out here.
Yeah.
So there's so what the attorney does here is the same thing you guys are paying for an escrow service for.
At about the same rate?
Yeah, honestly.
Yeah, my closing costs were substantially less
Yep.
based on the dollar amount of the transactions we're talking about than what I would have paid in California. I paid a lot more sell my house than I did to buy a house and the other properties I
The
bought.
title costs are a lot cheaper here too, because the litigation is a fraction of what you guys experience.
And that's the bottom line right there. Is that, you can argue, well, you're going to pay a lawyer, $500 to sit this open or to come to the closing. Yeah, that's $500 or $1,000, even if that's what it is. But how much is it going to cost you to, pay the lawyer to go over depositions and to go over interrogatories and to attend the mediation and all the other things that can be cut back if you have a different kind of closing? I just think it's a better system. And plus, at the get-go, I signed a buyer broker representation form because my agent wasn't going to move forward on any of the transactions we did without one, period, end of story. Not a discussion to be had.
Correct. That is absolutely true. I've never done a transaction here without the signature on a buyer representation form. It would be unheard of.
And John, honestly, you've been encouraging that for years. I mean, as long as I can remember, and I know plenty of people that do use it, and I know plenty of people that don't. And whether or not that becomes mandatory here in California, remains to be seen. But there's already been discussion, obviously, about that.
Right.
I think it becoming mandatory is the solution, because what's the number one objection you all have of using it, right? Every one of your lawyers tells you to use it. Every broker wants everyone to use it. But the number one objection is, if I put a contract in front of a buyer, they're going to go down the street or the next cubicle to somebody who doesn't require them to sign anything. So that's the problem. If everybody in the entire system is all required to have that document signed, then the number one objection for getting a buyer representation agreement signed goes away.
Right. Period.
So let me go back over to something you mentioned, John, and Dave, you mentioned a couple of times talking about dual agency. In fact, John, I think you said it was number 2 on NAR's top issue list. So number 1. So is that agent representing both party dual agency, or is that transactions within the same brokerage dual agency? And do you see dual agency going away in California?
Yes, yes, and no.
Simple answer.
If it's a situation where Wendy's representing both the buyer and the seller, well, that's classic dual agency. If one of Barbara's agents is representing the seller and another agent in her office representing the buyer, then Barbara is representing both sides because she's the broker. Therefore, the agents then, according to the Hariki case, will then assume a dual agency by virtue of that. That was the Hariki case that came down a couple of years ago. Do I see it going away? No, not necessarily. But I don't have a crystal ball. I mean, I don't know if Dave, you and Ed agree, but I never know what the California legislature is going to do on any given moment.
Except that you can always guarantee they're going to do what the trial lawyers want. And
Yeah,
so since the trial lawyers are more powerful than the realtors, I guarantee you it's not going away.
Right.
Because it's a great boon for trial lawyers to have this fuzziness of your fiduciary, right? If I sneeze in the wrong direction, right, then I picked up 3 buyer clients who can sue me for fiduciary duty. Trial lawyers love this. And so I don't see that changing anytime soon. Realize in most other states, we don't have this problem, right? This is a California, again, unique thing. In other states, you have what's called designated agency, meaning that a broker can designate one of their agents to represent the buyer, and they can designate a different agent to represent the seller. And that will not be considered a dual agency relationship at a broker level. Dual agency is limited only when the same human being represents both sides. That's how other states handle it. You guys are in being in California, that's not how it works. Dual agency is up at the broker level, and I don't see a scenario where that's going to change anytime soon, because it's a big wash of money to trial lawyers.
I'm not so sure, Ed. I mean, you know, representing, and I didn't do this, buyers in litigation is a tough go for these lawyers because, again, sellers are not insured. The attorney's fees that it takes, the time, the energy it takes to bring a case against not only agents, but principals, you know, typically sellers, home inspectors, you name it, it can be cost prohibitive. And I talk to a lot of the buyers' attorneys now. We weren't on such great terms when I was practicing, but now that I'm mediating, again, I have this practice where I'll pick up the phone and talk to the lawyers. As soon as I get the briefs, I'll spend time with them. I don't bill them for that. I just spend time because I want the case to be part of my DNA. I want to understand where they're coming from, what they're really looking for, and where their clients are coming from. So, you know, I talk to obviously the attorneys for the agents and the sellers, everybody. You know, you take, for example, the TDS. The TDS, I think, is a terrific form. It's statutorily required, 1102.1 and following of the California Civil Code. I think that's a good form. And then you take C.A.R.'s SPQ, and you really, I mean, if people approach these forms with an open mind to do the Vulcan mind meld, that's the seller's job, to do the Vulcan mind meld with the buyers and the agents and teach them everything they know about that property. Well, I'll tell you what, we have a lot of successful transactions, but it does take agents who are diligent, who are going to work hard. You can't read a seller's mind, but again, I'm going to go back to it. I'm sorry for repeating it. If the SPQ and the TDS are filled out and the explanations aren't there, following the check boxes, then we've got a problem. And that's where the agents are the gatekeepers of the transaction. You folks have the ability to not only, you know, handle a transaction really well, do everything you can, but to develop loyalty among the buyers and sellers. This agent is terrific. And so, you know, for the following reasons. Anyway, I'm rambling, but I do think that sometimes the legislature can come up with terrific ideas. I don't think it's really a consistent thing, but the other thing that we have to look at are the jury instructions and who creates the jury instructions, the California instructions, Casey, because that's what dictates what's going to happen at trial, or that gives the parties the law. Although I was just summoned for jury duty, my wife reminded me that she sat on a jury, and the lawyers were terrific. They argued the law and the facts, and then the jury ignored both and did what they wanted to do. So it's a scary process. I did like what John said about the parties sitting together, you know, at a closing back east, any place but California, right? When we sold our property in San Diego, we spent time with we loved the sellers, or rather the buyer's agent, and got to know her and the principals and have talked to them and become friends. Same thing with the folks who are our sellers of our unit that we're living in here in the hills. So, and I've discovered some stuff that we should have been told about that I think the sellers knew about. I'm not going to do anything about it. Maybe that's atypical. But one thing we try to do in mediation, as we did as attorneys, is we tell people bluntly, the parties, what it's going to cost to see this case through. Unless the attorney's taking the case on behalf of the buyer on a contingency. But on an hourly basis, they can hardly make out. It's a tough go. So don't blame the lawyers for everything.
No, blame the insurance companies, because we've settled a couple of cases of mediation that were my cases initially, just recently. And both of the cases settled not because of the merits of the claim. Neither case, in my view, and I'm pretty conservative. I know what to look for. I can find that needle in the haystack. Neither case had a needle. But what the insurance company is looking at is what? Cost of defense.
Yep.
And they're trying to, and so your carrier is not really interested in justice. If it's going to cost, if I can get out of a case for write a check for $30,000, or you're going to charge me $75 to defend it, I'm out of this case every time. And the plaintiff's bar knows that. So then you add to that dual agency where there's a double shot of fiduciary duty. And it just seems to me that I happen to agree with Ed that trial lawyer is very powerful in California. They like dual agency, at least today. Now, who knows what's going to happen down the line? Because California is probably one of the most susceptible states I've ever seen to lobbyism. And it's going to be, you'll see what's going to happen down the road, but I don't see it changing right now. But it is number one, so far as NAR can tell, on the hit parade for getting sued. If you're a dual agent, you're the most likely candidate, according to NAR insurance, to get sued. Number two is a property manager.
Well, and
right.
choosing the appropriate insurance carrier to provide your E&O is really important too. Is the carrier admitted in the state of California? How much is the reserve of the deductible? What is the best rating? Is it best or goods or something? I don't know. There's a rating system for insurance companies that we used to look at with our clients all the time. Right. Is it affordable? It's critical because chances are you're going to get sued.
Well, I haven't seen any new questions come through the chat.
I was just going to say, most of the time when you get sued, and I hear this all the time, I'm sure both of you, Ed and David, you hear it too. Why should I mediate? Why should I care? I didn't do anything wrong. Get that out of your mind. It doesn't matter. You might have been Mother Teresa in that transaction. It doesn't matter. It's really what the evidence will show, how things are going to work out. But at the end of the day, for the insurance company, it's going to be, if they go to mediation, the cost of defense. Now, if you got two insurance companies, or it's conceivable that there's even going to be a more likely chance that you're going to settle, because the adjuster is going to make the call, not the parties. Your policy doesn't allow you to say no to a settlement. So anyway, I just think that I agree with both Ed and David. You may get sued. Treat it like a business issue. It's not personal. It's just business.
It's time consuming. It's expensive. It's
emotional. It's very. I think that David, you and I were on a panel, and it was either you or Steve that made the comment. I've never, in 40 some odd years, between the three of us, we had like over 100 years of practice. None of us have never sat next to a happy defendant. Right? You're going to be happy.
Go ahead, John.
No, I was just saying, you're not going to be happy because you got your deductible to pay. You feel like you're being victimized because you really don't feel you did anything wrong most of the time. You've got a year or two of stress, family issues, just a lot of stuff to why I think personally, I love mediation. I go to mediation whenever I'm allowed to.
On down.
I'm not a big fan of arbitration, to be perfectly honest, but I am a fan of mediation.
So I was just going to say, I don't see really any new questions coming in. I've got one more for Ed, though. There's no doubt that, everything's starting to change, right? The industry's changing, forms are going to be changing. We got new looks to stuff. Any improvements that we can expect to see coming from CRMLS here in the near future?
Sure, yeah, well, appreciate that. That's a kind of a good question. One of the things that CRMLS is kind of preparing for this new world, I'll be frank, we've been strategically planning for these events for the last about 4 years. So these things coming down the pike are not new to us. And in that capacity, we are requiring and we're trying to collect and deliver to you a lot more data and a lot more information. And that's been a big technological lift. So we've really increased our headcount. We're up to 130 employees now at CRMLS. And a big chunk of that has been in the technological fields, hiring developers, guys writing codes. And we've really tried to bring more data into the database that is beyond just listing data. And we're working on building tools and platforms to deliver that information back to you as the brokerage community, and to get that information and data into your hands. But because no one else is doing this, we're having to build this from scratch, right? And that's why we've had to kind of increase our ranks on the technological side. And we're getting closer to where we're going to be able to start delivering some of that product and some of those experiences back out to you over this next year. But it's been multiple years in coming, because that's what it takes to build some of these, some of these technologies, again, from scratch. And we're really hoping that will enhance the nature of what cooperation is. I can tell you at CRMLS, we're not concerned if compensation leaves the MLS. We think the true value of what the MLS is your cooperation, right? How you guys come together, you agree under a set of rules that you all agree to cooperate with one another, to show each other's listings, let each other into each other's homes, the technology on how to schedule those appointments, right? Lock boxes, right? All of these elements are what really make the MLS, not the fact that, this is how you share, how your fee gets paid. That can be handled in a contract. That's easy, honestly. It's not that hard. And so those are some of the things that CRMLS is moving forward with, in really trying to gather information, protect that information, and deliver it back to a way that you as the brokers and agents can use that information to give your clients, whether that's a buyer or a seller or investor, better, more relevant, more accurate advice for them to make good real estate choices. Great.
Nice to know that everyone's, kind of staying ahead of the curve, trying to be proactive instead of reactive. So I appreciate what CRMLS is doing. I haven't seen any other questions come in, so I'm going to judge that we're about ready to wrap up. But if you guys could all maybe do a virtual round of applause. John, Ed, and Dave, thank you so much for spending some time with us today. For all of the participants here, we will get a copy of this recorded webinar out in the next couple of days. So be on the lookout for that. I know there are some questions that maybe didn't, you may have missed the beginning portion or the end portion. So know that we will get that out. But Dave, Ed, John, thank you once again so much for sharing all of this information. That is the power of educating ourselves. And we definitely appreciate you taking the time to do that.
Well, thank you. I want to personally thank David and Edward for responding affirmatively to the invitation. You guys are both always so generous with your time. And so when Connie asked me to put this together, I knew who I wanted as the moderator. You did a great job, Adam. Thank you. And David and Ed, as always, great information. So I want to thank both of you on behalf of the association and its board of directors. So, oh, one more thing. Be careful of your signs. I was talking to the professional standards administrators. They're getting an awful lot of calls about people putting their signs in the public right of way and not taking them down in time. And what ends up happening sometimes is the city gets upset and says, you know what? We're going to withdraw our permission to allow you to put signs in the public right of way. So be good boys and girls and take your signs down when you're supposed to, so that you don't run afoul of the local jurisdiction. Thank you. Thanks, Adam. I forgot to mention that.
Nope, great tip. Great tip. All right, guys. Well, that'll wrap it up for the day. Thank you so much for joining us. We look forward to seeing you at one of our future events. And based on the feedback we're seeing so far in the chat, looks like everyone enjoyed this. So we'll look to continue having these types of informational panels out to you to bring you as much information as possible. Thanks again. And on behalf of the association, make it a great day.